the case of the Indian blasphemy law.
Thank you, Professor Pandey, and thank you especially to Professor Subodh and Dr. Mukhopadhyay for allowing me to make my debut on the seminar circuit here on home soil in front of friends. My paper, it would take me not more than 15 minutes to read my paper, so kindly bear with me till then. On April 5, 1957, the Chief Justice of India, Subhiranjan Das, delivered the judgment of the Supreme Court on a petition challenging the constitutional validity of Section 295A of the Indian Penal Code, which penalizes, quote, deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs, unquote. The petition had been filed exactly 4 months earlier on December 5, 1956 by one Ramjilal Modi, editor, printer and publisher of a monthly magazine devoted to cow protection called Corruption. He had been convicted under the said section 3 years earlier on November 16, 1953 by the Sessions Court of Kanpur for an article he had published in this magazine the previous November, that is, in its November 1952 issue. The High Court of Hyderabad, where he applied the verdict, appealed the verdict of the Sessions Court in its judgment, delivered 3 years later on October 25, 1956, reduced his sentence of imprisonment from 18 months rigorous imprisonment to 12 months, and the fine from Rs 2,000 to Rs 250. But it upheld his conviction, stating, quote, that the article was published with the deliberate and malicious intention of outraging the religious feelings of Muslims, unquote. Having failed to secure an acquittal a second straight time, Modi, it appears, decided to change tactics and challenge the constitutionality of 295A itself. Thus came about the petition on which the Supreme Court delivered its aforementioned judgment on April 5, 1957. Filed under Article 32 of the Constitution, that is to say, the right to constitutional remedies, it claimed that Section 295A of the IPC infringed upon Modi's fundamental right to freedom of speech and expression conferred on all citizens by Article 19(1)A of the Constitution. Therefore, it contended that the section should be declared unconstitutional and that his conviction under that section should subsequently be quashed. Although Section 295A is today found in the IPC, it was not part of the IPC when the code was passed into law on October 6, 1860. In fact, Section 295A would not become part of the code for another 77 years until 1927, but another pamphlet entitled Rangila Rasool, intended to, quote, make a wanton attack upon the Prophet of Islam, to hold him to ridicule and contempt, to ridicule his religion, and thus to wound the feelings of his followers, unquote, prompted the Central Legislative Assembly to insert it in. Back then, it read, quote, whoever with deliberate and malicious intention of outraging the religious feelings of any class of His Majesty's subjects by certain words, insults, or attempts to insult the religion or the religious beliefs of that class shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. A quarter of a century later, when Ramjilal Modi was convicted under it in 1953, it was still the same, except for the phrase, His Majesty's subjects, which had been substituted with citizens of India 3 years earlier in 1950. That was because on January 26 of that year, the Constitution of India came into force. Not only did the Constitution confer upon all citizens the right to freedom of speech and expression in Article 19(1)A, but in Article 32, it also guaranteed the right to move the Supreme Court for the enforcement of that, as well as every other right in Part 3 of the Constitution. Moreover, declared Article 13(1) that all laws inconsistent with these fundamental rights, to the extent of such inconsistency, will be void. Thus was Modi, a citizen of India exercising his fundamental rights, able to file a petition challenging the constitutionality of Section 295A. However, his counsel based the claim that Section 295A was void not just on the contention that it infringed upon Modi's right to freedom of speech and expression, but that it constituted an unreasonable restriction on the exercise of that right. Such a contention had to be made because of Article 19.2, which then stated that the right to freedom of speech and expression shall not, quote, affect the operation of any existing law insofar as such law imposes reasonable restrictions on the exercise of the right in the interests of the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense, unquote. In other words, the real fundamental right was what is left after the restriction has been imposed, and therefore, said a Supreme Court justice, the citizen alleging violation of his fundamental right must also show that the restriction is unreasonable. This is because, continued the same justice, there is always a presumption in favor of the constitutionality of an enactment, and the burden is upon him who attacks it to show that there has been a clear violation of the constitutional principles. The courts, it is accepted, must presume that the legislature is the best judge of what is good for the community, by whose suffrage it comes into existence, unquote. Thus, the question before the Supreme Court in Modi's case was not whether the impugned section infringed upon the right to freedom of speech and expression, but whether it could, quote, properly said to be a law imposing reasonable restrictions on the exercise of the fundamental right to freedom of speech and expression in the interests of public order, unquote. But why public order? Because it was believed to be the only thing in Article 19.2 that could possibly be relied upon by the state as affording a justification for its claim for the validity of the impugned section. Accordingly then, argued Modi's counsel that a law circumscribing the freedom of speech and expression may be in the interest of public order only if the likelihood of public disorder is made part of the offense and its prevention the law's primary purpose. That was not the case with Section 295A, for although the legislative intent of the law was to prevent public disorder, that intent was not reflected in the language used in the law, which was limited to the insult of religion or religious beliefs. It was also not reflected in the location of the section in the IPC, where it was placed in Chapter 15 of the IPC, which enumerated offences to religion, and not Chapter 8, which listed offences against the public tranquility. Now, since such an insult of a class of Indian citizens did not necessarily lead to public disorder, the impugned section ended up imposing an unreasonable restriction on the exercise of the right to freedom of speech and expression in all those cases where public disorder was not a proximate consequence. Also, since the section as it stood could not demarcate the reasonable restrictions it imposed upon this fundamental right from the unreasonable ones, it would perpetually remain in potential violation of that right, and therefore had to be declared wholly unconstitutional and void. In support of these arguments, Modi's counsel cited as precedent 3 earlier judgments delivered by the Supreme Court. The same court, however, rejected these arguments. They held that the precedents cited were inapplicable in this case, but they were based on Article 19.2 as it was until its amendment by Parliament in 1951. In the amended Article 19.2, they continue, the language employed in Article 19.2 is in the interest of and not for the maintenance of public order, which, as one of them had pointed out in an earlier case, makes the ambit of the protection very wide. Even when a law may not have been designed to maintain public order, it may still have been enacted in the interest of the same. On the location of Section 295A in IPC's chapter on offences relating to religion and not on offences against the public tranquility, they refer to the fundamental right to freedom of religion, that is to say, Articles 25 and 26 of the Constitution, which were also subject to public order, morality and health. Since even the freedom of religion could be restricted in the interest of public order, it could not be argued that a law creating an offence relating to religion has no bearing whatsoever on public order, and therefore cannot possibly be in the interest of the same. There was still, however, the question of the potentially unconstitutional use of the law in those cases where insults or attempts to insult the religion or the religious beliefs of a class of citizens did not lead to public disorder. To it, the court responded referring to the expression, again with the expression, in the interest of, that it was wide enough to permit penalizing any such act of insult that could potentially lead to public disorder, even when in some cases it did not actually lead to a breach of public order. Moreover, they argue, Section 295A did not criminalize each and every act of insult or attempt to insult the religion or the religious beliefs of a class of citizens, but only those that are perpetrated with the quote, deliberate and malicious intention of outraging the religious feelings of that class, unquote. Since any such deliberate and malicious act of insult could only have been calculated to disrupt public order, it fell well within the protection of Article 19(2), and the question of its unconstitutional use did not arise. Hence, declared the Supreme Court, Ramjilal Modi's application was dismissed, thereby confirming the constitutionality of Section 295A. In the light of the discussion above, it is not too far-fetched to suggest that had it not been for Article 19(2), particularly the amended Article 19(2), Section 295A would probably have been declared unconstitutional. Not only Section 295A, since 1950, other laws of colonial provenance too have survived challenges to their constitutionality for allegedly violating the right to freedom of speech and expression. If the judgment described here is any indication, then the provisions of Article 19(2) were invoked to save them from being declared void as well, which begs the question, why was Article 19(2) amended? Why was it even included in the Constitution, when at the time of its drafting, there was no precedent for it? Its amendment, which was also the first amendment to the Constitution, was prompted by the Ramesh Thapar case, one of the three cited by Ramjilal Modi's counsel as precedents in his plea. In its judgment delivered exactly 5 months after the Constitution came into force, the Supreme Court declared the Madras Maintenance of Public Safety Act 1949 unconstitutional, a ruling that Vallabhbhai Patel, then Home Minister of India, thought, quote, knocks the bottom out of most of our penal laws for the control and regulation of the press, unquote. Since Jawaharlal Nehru, then Prime Minister of India, concurred, he set in motion the process for amending Article 19(2), culminated in him the Constitution First Amendment Bill in Parliament almost a year later on May 12, 1951, which was passed by a vote of 228 to 20 3 weeks later on June 2. The purpose of the amendment was to retrospectively revise and validate from January 26, 1950, all existing laws that had been rendered void by the judiciary over the preceding year. Not only that, but it was also to expand the language of Article 19(2) in a way that would provide greater constitutional cover to Parliament from judicial oversight. Many of the members who constituted the Provisional Parliament that passed this amendment were also part of the Constituent Assembly that passed the original Article 19(2). It was then drafted because, felt many members, quote, having got our freedom, the state that has been brought into existence is an infant state, which has to pass through various kinds of travail, and what we could do to ensure that the state continues to function unimpaired should be assured, even if it entails an abridgment of the rights conferred by this article, unquote. It was also argued that fundamental rights are nowhere absolute, and as, quote, the gift of the state, it does not follow that the state cannot qualify them, unquote. Therefore, instead of formulating the fundamental rights in absolute terms and depending upon the Supreme Court to come to the rescue of Parliament by inventing the doctrine of police power like it happened in the United States of America, the Constitution permitted the state directly to impose limitations upon the fundamental rights. There was thus really no difference in the result. What the USA had done indirectly, India did directly. In both cases, the fundamental rights were not absolute. Fortunately, in the words of Bhimrao Ramji Ambedkar, the chairman of the drafting committee, they were rebels. These rebels, although far fewer in number than and ultimately overruled by the majority, will at least leave for posterity their objections. They argue that nothing in subclause A of Article 19 shall, quote, affect the operation of any existing laws, unquote, many of whom had been enacted by a colonial government bent on suppressing civil liberties. Then, quote, where is the change ushered in and so loudly talked of, unquote. the main purpose of declaring a right as fundamental was, quote, to safeguard the freedom of the citizen against any interference by the ordinary legislature and the executive of the day, unquote. But Article 19.2 made the freedom of speech and expression, quote, so precarious and entirely left at the mercy of the legislature that the whole beauty and the charm has been taken away, unquote. To the contention that there was no real difference between India and the USA, it was argued that whereas in those countries the judiciary regulated the fundamental rights and the extent of the restrictions to be imposed, under Article 19.2 in India, the legislature was being empowered with these powers. Thus, the sphere of the Supreme Court would be very limited. The only question before it would be whether legislation concerned fell within the protection of Article 19.2. Once it was found by the court that the government honestly believed that the legislation was needed in the interest of the provision in Article 19.2, there would be nothing left for its interference. The proviso, quote, had been so worded as to remove from the Supreme Court its competence to consider and determine whether in fact there were circumstances justifying such legislation. The actual provisions and the extent of the restrictions imposed would be out of the scope of judicial determination, unquote. I end with Hukum Singh, then a minor member of the Constituent Assembly, who would go on to become Speaker of the Lok Sabha, commending an amendment deleting clauses 2 to 6 of Article 19 on December 2nd, 1948. Quote, the very object of a Bill of Rights is to place these rights out of the influence of the ordinary legislature. And if, as under clauses 2 to 6 of Article 19, we leave it to this very body, which in a democracy is nothing beyond one political party, to finally judge when these rights, so sacred on paper and glorified as fundamentals, are to be extinguished, we are certainly making these freedoms illusory. I, for one, concur wholeheartedly. What about you? Thank you.